Hello, my name is Mrs. Kane and I am Director of the eBaccalaureate Suite. I actually do teach, though, A-level law, which falls under the Social Studies department. So in A-level law, we learn about a variety of legal principles. So there are three components. Exam paper 1 is looking at criminal law, murder, manslaughter, theft, property, burglary. It's also looking at what we call GBH and actual bodily harm. We also learn about the development of barristers, solicitors. We look at our laws first. We look at statutory interpretation and the parliamentary lawmaking process. The second exam paper, we look at fault, and in law we call that tort. So we look at negligence, we look at something called occupiers liability, which is essentially saying our business is looking after visitors who are lawful visitors to their premises. And we look at trespassers as well, which is quite a confrontational issue because we actually have to protect trespassers too. We look at vicarious liability, the role of employers, and then we look at torts connected to land. So that's component 2. And the last component is looking at moral issues within law. Should assisted dying be legalised? So should euthanasia go through Parliament and be allowed to support those people who are maybe terminally ill and are finding life very difficult? We also look at law and justice. Are we ensuring in this country that everyone has got access to justice? And are we reflecting society itself? And then finally, we look at law and technology. Everywhere around us, without us even realising it, our life is being monitored. CCTV is picking up our everyday movements. What's happening with that information? Who is using that information? Is that abuse of our human legal rights? And then finally, this one complements business. We look at contract law. We look at how contracts are formulated, how they are offered, how they are accepted, and also how contracts can be terminated if there has been what's called a misrepresentation, false statements.
Welcome to the Year 13 Law class. In Year 13, you will cover negligence, murder and manslaughter.
My Lordship, my submissions are as follows. Firstly, it wouldn't be fair, just and reasonable to impose a duty of care on the Ministry of Justice when there was no proximity when Mr Palmer assumed responsibility. Secondly, there was nothing to suggest Mr Palmer was more at risk than any other of the inmates. Thirdly, holding my client liable would lead to the floodgate argument and lead to a whole load of other claims being imposed on the Ministry of Justice.
My learner friend, I wish to take you through each submission in turn, unless your Lordship directs me otherwise. Thank you. My first submission. In order for the Ministry of Justice to owe a duty of care to Mr Palmer, one has to look at if the Ministry of Justice owed a duty of care in order for negligence to be established. I'd like to direct your Lordship's attention to a statement Lord Bridge made in Caparo Industries plc versus Dykeman 1990, cited in the Court of Appeal on page 617. Would your Lordship like a brief summary of the facts? Caparo Industries purchased shares in Fidelity plc in reliance of the accounts which stated that the company had made a pre-tax of £1.3 million. In fact, Fidelity had made a loss of over £400,000. Caparo brought an action against the auditors claiming they were negligent in certifying the accounts.
The 3-stage in which all 3 requirements must be satisfied in order for there to be a duty of care. The 3 stages are 1. Foreseeability that the D's failure to take care could cause damage to C, and 2. A relationship of proximity between the C and D, and 3. It is fair, just and reasonable that the law should recognise a duty on the D to take reasonable care and not to cause damage to the C.
My learned friend, if the first 2 parts of the Caparo test are satisfied, it wouldn't be fair, just and reasonable to impose the duty of care on the Ministry of Justice when there was no proximity when Mr Palmer assumed responsibility. To support this, may I direct your Lordship's attention to the outcomes in the case of Mark, Rich and Co. v Bishop Rockmarine Co. Ltd. for 1996, cited in the Court of Appeal. Would your Lordship like a brief summary of the facts? Okay, thank you. A surveyor acting on behalf of the Classification Society had recommended, after repairs specified by him had been carried out, a vessel should be allowed to proceed. It was lost at sea. It was held that the cargo owners couldn't recover damages from the Classification Society. There was no contact between them, and it wasn't even suggested that the cargo owners knew of the survey. They simply relied on the ownerships to keep the vessel seaworthy. Furthermore, the Ministry of Justice can only be held liable for what they have done, not for what they have not done. The Ministry of Justice can't owe a duty of care over an act they didn't commit themselves. I refer your attention to Lord Hoffman's quote stated in paragraph 27 in the opinions in the Lord of Appeal for Judgment in the case of Sutrandahar v National Environmental Research Council 2006, cited in the United Kingdom House of Lords 33. Would your Lordship like a brief summary of the facts in the case? In Sutrandahar v National Environmental Research Council, the claimant was poisoned by arsenic after drinking water from an irrigation well, which had been tested for toxins but not arsenic. On behalf of the British government, by the British,
Watch our Year 13 barristers act out a negligence case.
My learned friend, Lord Bridge, stated at page 617, what emerges that, in addition to the foreseeability of damage, necessary ingredients in any situation giving rise to a duty of care that should exist between the party owing the duty and the party to whom it is owed, a relationship characterised by the law as one of proximity or neighbourhood, and that the situation should be one in which the court considers it fair, just and reasonable. What concludes this statement?
My Lordship, I respectfully ask that you consider the points brought before the court and in consideration move to a motion of liability via negligence.
Court adjourned.
So you will take 3 exams in law, as mentioned in the content outline. Each paper consists of a section A, where there are 8-mark questions and 15-mark questions, where you are describing the process of law and then you're looking at the advantages of the law or the potential disadvantages. Section B is where you will be applying your skills of law and your understanding of law, and you will be looking at scenarios that have happened in the past and have gone through the criminal courts or the civil courts, and you will apply your skills to those scenarios to decide whether you believe that person is guilty or not guilty, or, as we say in law, liable or not liable. So all 3 papers mirror each other in exactly the same way. 2 hours each, worth 33.3%.